Hi, this is Jacob Sapochnick, and thank you for watching our video, and welcome to this particular video. I'm going to talk about what happened to one of our clients who came on a visa waiver to the United States, overstayed their visa, and during that process was apprehended by the Border Patrol and was about to be deported from the US. And we tried to negotiate a prosecutorial discretion to cancel his removal and then refile his case and get him adjusted. It's an interesting case because there is a particular law that governs the people who enter the United States on a visa waiver. A visa waiver is a 90-day privilege that most European countries have when their visitors come to the US. Also, countries like Japan and Argentina and others are able to use the visa waiver to come to the US as visitors for 90 days. The problem is, when you enter the United States on the visa waiver, you waive your rights to most of the privileges that other people who come on other visas get. For example, the right to a hearing, the right to appear before an immigration judge in case something happens. Most visa waiver people who enter the United States on that visa are not aware that when they come here, they must depart after 90 days. They cannot extend it, they cannot adjust their status unless they're married to a US citizen. This is the only exception. And even that exception had some major changes last year. Well, in our case, our client was a person from a European country. He entered the United States many years ago, more than 15, and has been here, overstayed his 90 days, and then married a United States citizen a few years ago. After the marriage, they filed their adjustment of status case, and then they went to the interview, thinking that they're going to be approved. Well, what happened is that in San Diego County, where they started to deny cases where people who overstayed their visa waiver, even if they're married to a United States citizen, could not get their green card. And so that particular client was denied. And then he filed a motion, and his attorney filed a motion, and still the motion was denied. And so the client did not know what to do. They've decided to refile their case based on advice from another attorney. Once the case was refiled, a few weeks later, the client was arrested by the Border Patrol due to a tip, or we're not sure how it happened. And he was put into a removal proceedings. At that point, the client contacted our office because his other attorney did not know what to do. When I got the call, I told the client, the problem is, when his wife called me, is that he has no protection of court. He's not going to be able to go to court to protect himself. In fact, when I called his deportation officer, he was already put into a removal proceedings, and he was about to be sent back to his home country in Europe. What we try to do at that point is, I tried to explain to the deportation officer that we would like to exercise prosecutorial discretion in this case, a procedure that will allow the officer to cancel the removal at that point, because our client filed for his adjustment of status before he was put in proceedings. The deportation officer initially refused. At that point, we combined several case law that shows that US immigration still had jurisdiction over this client, even though he was not in removal proceedings. They had jurisdiction over that client because his adjustment of status was filed before he was arrested. Finally, we managed to get the supervisor to accept our arguments, and they accepted the prosecutorial discretion process in this case. They dropped the removal and they paroled the client back in. He was able to go through his adjustment of status case, and at the end of the interview, he was approved because it was a bona fide marriage. Now, the conclusion of this case is that visa waiver overstays are very difficult cases. And even though now immigration accepted the fact that they are, even after overstay, the clients should be allowed to adjust, we never know when those cases are going to be again put under very tight scrutiny. The bottom line is that if a client who overstayed the visa waiver ends up in removal proceeding before an adjustment of status is filed, there is no recourse right now. Recent case law cite that if a client is apprehended by the Border Patrol and they are in removal proceedings and they overstay the visa waiver, they have no chance to stay in the US. They're going to have to be removed. Therefore, we advise all clients that have overstayed the visa waiver and they are able to file their adjustment of status, do so immediately. If there's a chance for them to be put in proceedings, it's going to be very difficult to fight it, if not impossible, and allow them to stay here. So in this case, we have a very good and positive conclusion, but we heard of other cases that the clients were not able to fight. They were not able to convince the Border Patrol to drop their charges, and they had to be removed from the US. Even with complicated cases like the Visa Waiver Overstay, prosecutorial discretion is a great way to try to save the clients before they are removed from the United States. Prosecutorial discretion allows the attorney to negotiate with the government to allow them to drop the case or to administratively close the case or to parole the person into the United States. It's a very powerful tool, and attorneys should be able to use it depending on the case. Once again, thank you for watching, and if you have any questions, please email us at any time.